40 থেকে শুরু। হ্যাঁ।
এর আগে থেকে ছিল তো জানা
কি হলো?
Lordships, in item number Lordships, in item number 1, yesterday say served the copy in WhatsApp. Lordship, this matter related to cheat fund and spongy matter, and all the matter transferred to the Chief Metropolitan Second Court, Calcutta, and the principal bench has the jurisdiction. Earlier coordinate bench, we have already notified it from 2023.
দেখি দাও। No, if we
tomorrow, madam. This matter was taken up before justice practice court, but it was directed transfer this matter before the
Maybe all that
instructs for this matter appearing.
it is a government notification, Mr. Shahapur.
Filed before the principal. Then matter was transferred before the circuit.
Maybe on that time, no one can intimate the court.
Not before the circuit bench. This particular matter.
Give him copies of this, come back tomorrow. He wants a day's accommodation. Give him copies of this. You are very well aware because you appeared in one of the matters.
And then his lordship directed transfer.
What transfer? Now you have to go to the designated court.
At that time, his lordship.
So don't press it here.
Tomorrow.
Chalo, next.
Number 2.
For the state matter.
Nahi, chalo.
Item 3.
We ask for the state matter.
Passed over, all passed over.
First. Item 4.
For the state, my lord.
For my lord, I'm appearing, my lord, for the petition. I'm online. My lord, would your lordship permit me to?
Bad
get online
connectivity,
and do
Mr.
this part?
Banerjee. Garbled, totally garbled. Cannot understand anything what you are saying.
My lord,
It's freezing. Every half a second it's freezing. এইভাবে মামলা হয়।
my lord, your lordship can't hear me.
No, it's garbled, broken, and the frame is freezing every
Oh my God.
second.
My lord, then may I link? I'll be there. My lord, I'll be there present on 9th. On 9th. Understand? I'm saying
Yes.
keep this matter on 9th.
It's on 9th.
I'll be physically
9th.
present.
You are for the state? 9th. He'll be here physically, Mr. Banerjee.
Keep it on 9th. I'll be physically present. I'll do it. Yes. I'll do it on 9th.
Item 5.
State is there? Madam, just see if the state is there. Why are you starting your submission? Pass over. Oh, you are there. Yes.
My lord, item number 5, 1 day accommodation, but I'm holding the seal.
You are an Indian national. Why haven't you annexed to your petition? Why haven't you annexed to the petition? What document? Only Aadhaar card. Mr. Chakraborty, do this, you verify this, whether this is a genuine
My lord.
Aadhaar card or not. The charge is
They have
under,
not enclosed the copy in the our petition, so we required a copy. We have to send for the.
not annexed to your petition,
normal.
Aadhaar card.
You know, Fakunu, na? Pachkudu alias Abdul Rasid. They have not annexed.
The charge is under sections 14, capital A, oblique 14C, capital C of Foreigners Act. Stop. The petitioner says that he is an Indian national. Stop. He hands over certain documents to learned state counsel in support of such claim. Paragraph, let the state verify the authenticity of the documents produced by the petitioner and file a report. How long?
Monday.
Monday. On the next date, paragraph, list the matter, Monday date the other.
Item 8. Seven. I put it.
Who was arrested and he was granted statutory bail, finding of charge sheet with the case. Principal from bail by the.
Lord, who is the petitioner is the owner of the vehicle, my lord. But this is the 161 statement, my lord. Vehicle registration is also there, my lord.
161 of who accused?
Who is the driver?
Yes, but then the car is in your name.
Yes, yes.
There are many coordinates and petitions. One of the only confession statement.
You think it will help you?
From there, so there is no other confession, only confessional statement. I have not.
What forget about confessional statement. The car from which recovery has been made is registered in your name. Prima facie at this stage, no. Go and surrender, no anticipatory bail.
I want to say something.
Sure.
Page 123 is the registration certificate.
Yes, what else?
If there is no other conflict,
So this is the law laid down. Law laid down. You can produce a dozen. That is no precedent, Mr. Poddar. You know that better. I am not going to grant you bail. Go and surrender, obtain regular bail if you can. Issue. You are not pressed. কত নম্বর ছিল? সব
Item 8.
8,
9.
ঠিক আছে তো
8 আছে।
8, you are appearing. You are not the owner of the vehicle. No recovery. Yes, Mr. Ganguly.
Lordship, page 36 to 38, the statement of the arrested accused persons. From where
Co-accused person.
arrested accused persons
Yes,
Uh,
not
co-accused,
him. Co-accused
co-accused
persons,
persons.
161 statement.
statements.
Tufan Singh,
Lordship,
Yeshu. This is a fit case, but not where you are a registered owner of the vehicle.
Lordship, the owner of the vehicle is one Orchuna Bormon, wife of Muntu Bormon.
Not his wife.
No. Page 61 is the document, ownership document.
The petitioner says that there was no recovery of narcotics from him. Stop. He has been implicated solely on the basis of statement made by a co-accused person. Stop. Charge sheet.
No, Lordship, no CS. Investigation.
He is fully prepared to cooperate with the investigating officer. Stop. He prays for pre-arrest bail. Paragraph. Learned State Counsel, while opposing the prayer for bail, comma, in his usual fairness, admits that there was no recovery from this petitioner, and his implication is based on statement made by a co-accused person. Stop. Paragraph. In view of the aforesaid, comma, I am of the opinion that the petitioner has been able to tide over the restrictions in section 37 of the NDPS Act, and I am inclined to allow his prayer for anticipatory bail. না না কলকাতায় যেমন 25
Item 9. Item 10.
You're appealing for the state.
I would stay. Commercial quantity, petitioner name of the statement of
Yes, correct.
Well, 105 gram of brown sugar. my lord.
Intermediate. Intermediate. And
on the basis of statement of what?
but there was recovery also. Oh, not from the petitioner. Issue. Charge sheet.
No, my lord, charge sheet has yet not filed.
The petitioner says that there was no recovery of narcotics from him. Stop. Intermediate quantity of heroin,
Brown sugar. my lord.
brown sugar, was allegedly recovered from co-accused persons. Stop. He has been implicated solely on the basis of statements of co-accused persons. Stop. He is prepared to extend full cooperation to the investigating officer. Stop. He prays for anticipatory bail. Paragraph. Learned State Counsel, while opposing the prayer, comma, does not dispute that there was no recovery from this petitioner and intermediate quantity of narcotics is involved. Stop. Paragraph. In view of the aforesaid, the rigors of section 37 of the NDPS Act would not apply. Stop. I am inclined to allow the petitioner's prayer so long as he cooperates with the investigating officer.
Item 11.
I'm for the state of law.
I'm going to defer to complaint for short pass over lawsuit.
You're for
আমার
whom?
পাস ওভার কি ব্যাপার 3 দিন ধরে তোমাদের পাস ওভারই চলছে সিরিজ রিটার্নিং হিয়ার
Yesterday, Lordship.
Investigation is pending.
Who are you for?
De facto company.
What is the charge?
For 3 days they have,
No, yesterday you did the same thing.
yes, madam.
Yes,
We have detained the city on.
yes. Go and call your senior.
On his way, Lordship.
Prosecution is there.
Can be that.
Short passable Lordship.
Yes,
Petition number one.
Prosecution is more than enough.
Petition number one,
Hmm.
her daughter earlier. Made with the spawn of the deceased.
petitioner number one's daughter played with the victim's son.
This is.
This is victim, yes.
Thereafter, one kidnapping case was that they are granted bail. Thereafter, the daughter informed them that she was tortured. They. My lord, after the defect of. They meet with the parents of the son. Thereafter, some altercation and scuffling, and the disease filled out. Thereafter, he was died. This is. Page number one is the mother of the daughter, and page number two is the.
What is the,
Petition
petition number one is the mother and two is the, who is the prime accused, the father?
No,
All together. they-
all are equally.
But story is different. They have a love affair, they got married. And when they enter into
They
the
met
house
you.
of the deceased, all the family members, including all the petitioners, they came and entered into the house at night and ransacked the house and beaten all the family members and snatched from their custody that,
PM report?
yes, madam.
May I submit one thing?
PM report is there, but when
What
when
does
the
the
deceased was first admitted in the rural hospital, there was some injury report. The injury report is given here, then they shifted to another hospital and say shifted from another hospital and he died.
You consider the PM report, Lordship?
Let me see the PM. There would be multiple injuries if he was beaten up by all of them.
Kindly have a look at page 181. I have already flipped. First, they brought the injured person at the rural hospital.
No external injury mark seen.
Yes,
But
Lordship.
injury is grievous written.
Inconsistent, sir.
And Milord, moreover, Milord, said girl was not recovered till today.
Lordship, the same can with the.
And all the accused
As
person,
the petitioner for her mother, Lordship.
all the accused
They
person,
are from the petition, Lordship.
How do you explain this? No external injury mark seen, then says,
thereafter he died. Thereafter he died.
no, death may be for very many reasons, sir. This is a very strange injury report. Have you seen?
No, my lord, I have not seen. Lordship, no injury, Lordship. There is
No external injury mark
No, my
seen?
lord, so for the case is concerned, may I submit something, my lord?
Lordship,
So for the case is concerned, after attaining the age of majority, the de facto complaint son got married with the petitioner number one's daughter. They lodged a complaint. A case was initiated. When she appeared, the victim appeared and stated everything, they were enlarged on bail. From the district court premises, these petitioners tried to snatch that girl. But due to intervention of the local lawyers and other litigants, they failed. Subsequently, they returned to their respective houses. There, they attacked their the de facto complaint's elder daughter-in-law, who is carrying for 7 months. So the deceased went there to save her. He was brutally manhandled. Subsequently, succumbed to his.
Where is all this in the case diary?
Lordship, with the FIR,
That is,
Lordship,
that is,
with
he
the
can say.
Milord,
Eta diye daw.
if you also kindly see the
The
FI.
FIR is stated, Lordship, on 16
FIR.
on the incident occurred in court, and that this incident was occurred on 30 January, not on the same day, Lordship.
Charge sheet has been filed.
No, my lord.
Charge sheet has not been
but-
filed.
No, no.
It is
In the
a.
preliminary stage of investigation,
It is a part
that
of.
girl was not recovered and they trying to murder the said boy.
It is nothing but a case of honor killing, my lord. This is another mark of honor killing.
IO is there, my lord.
The victim girl affirmed the petition for her mother, Lordship.
Why,
No overnight statement. Lordship, kindly build the.
why have you not arrested? Because absconding.
Yes, my
They are
lord.
absconding.
Now kindly consider this. If we grant anticipatory bail with the condition that they will go and surrender within 14 days or whatever, you will at least get to interrogate her. Otherwise, you will not even get to interrogate her.
Lord, if
Consider
he-
that angle.
If he released on bail, they can manage everything. The investigation will be fast taken, my lord. At this stage at all.
Consider the PM report, Lordship.
The very initial
The
stage.
PM report also says grievous.
PM report, Lordship.
PM report, it also says grievous injury. Keshav, what kind of PM report is this? I don't know.
So far, our.
The
Lordship,
petition, the petitioners say that they have been falsely implicated. Stop.
no overnight claimant is.
The daughter of the petitioner number one married the son of the victim
The de facto complaint. A big victim.
of the victim. Stop. Thereafter, there were certain allegations of the girl being tortured. Stop. Her family, including these petitioners, brutally assaulted the family members of the boy. Stop. In the process, the victim, being the boy's father, sustained grievous injury and succumbed thereto. Stop. Paragraph. The petitioners say that they have no role to play in the alleged incident. Stop. They have been falsely implicated. Stop. If granted anticipatory bail, they will fully cooperate with the investigating officer. Paragraph. There is strong opposition to the prayer from the side of the state and the de facto complainant. Stop. They say that the petitioners and their families are influential people and will and the investigation will be prejudiced if they are granted anticipatory bail. Stop. Paragraph. I have seen the material in the case diary, including the injury report. Stop. The charge is serious. Stop. Investigation is going on and charge sheet is yet to be filed. Stop. Paragraph. On an overall assessment of the facts and circumstances of the case and the material on record, comma, I am of the view that this is not a fit case for grant of pre-arrest bail.
Marks of that.
Item 12.
Lordship, I am for the petition. Lordship, kindly sees page. Page 8 of my complaint petition. Is the letter of complaint dated 8/8/2024.
Yes.
Actually, on the first paragraph, Lordship kindly says such and such. Beg to lodge those written complaint against opposite parties, namely Mr. Sandeep Chatterjee, son of such and such, and Srimati Debosmita Bonik Chatterjee, wife of Sandeep Chatterjee. So these two were the opposite parties. But Lordship, the petitioner is the employee of these two persons. His name came where? Lordship kindly says the second paragraph, fifth line. So I paid rupees 1 lakh to Shomit Kumar Roy by check. Now check number is peculiar.
on dated such and such at his office, Siddhi Business Consultant, Arsi Road, apartment. such and such. This Siddhi Business Consultant is run by Mr. Sandeep Chatterjee and Debashmita Chatterjee.
So basically, the allegation is that they extracted money by promising job.
Job.
Yes, Lordship. In
Now,
Europe.
now, Lordship, I'm handing over one order of the coordinate bench where I moved on behalf of this Debashmita Banik Chatterjee. His bail was, her bail was granted, Lordship. They are the owner of the consultant and I am the manager. Employee of this Siddhi Business Consultant.
Considerations were different.
Lordship.
Yes, Lorships.
Happens to be a housewife.
Yes.
Prima facie, there is no possibility that she would flee from
Yes.
justice.
My submission is open.
Yes.
Yes. Lordship, I will invite your Lordships kindly see the conduct which is already submitted before your Lordships, that the receiving amount 1 lakh check received, and who is the manager, who is the main kingpin, it will be this ascertained after at the time of trial stage, not at this stage. So, and they are taking the advantage, those are unemployed and giving greeting opportunity to, they will send the Europe and get a job.
Is
And,
there any antecedent?
No, Lordship.
Is there any antecedent?
there is no
Are they
antecedent.
habitual offenders?
No.
Given the nature of the case, why do you need custodial interrogation? They'll cooperate fully with you.
Lordship.
If they don't cooperate, the bail will stand cancelled. Why do you need custodial
Actually,
interrogation?
Lordship, if they now they are absconding.
No, we are not
After
absconding.
getting bail,
Hmm.
they will maybe destroy some documents which is very much relevant at the time of trial. That was
If they wanted to destroy by now, they would have destroyed. So long. Keshu. What about this Shondeep? He didn't apply for.
No,
he's in
Lordship, this
custody.
matter is being ready as because the allegation, the check amount was never deposited in the account. We are collecting all those documents and will file the appeal application of Sandeep. These are all, huh? No, sir, this check number, Lordship, 00002.
Is a rather
it's
strange.
organized crime, Lordship.
Huh?
So organized crime.
Not.
James Bond.
Anyway, they'll cooperate. They'll cooperate. The petitioner says that he has been falsely implicated in this case. Stop. The allegation is that by promising to secure job for the de facto complainant, comma, the accused persons extracted rupees, how much total?
Here the Lordships
Against me, only 1 lakh deposited in the office by check.
The petitioner extracted.
transaction 75,000.
Petitioner extracted rupees 1 lakh
75,000.
from him. Stop. This was a false promise. Stop. Paragraph, the petitioner says that in no way he is involved in the alleged offense. Stop. He is fully prepared to cooperate with the investigating officer. Investigation is going on.
Lordship going on.
Stop. Paragraph, we find that a co-accused person to whom also the petitioner, the de facto complainant allegedly paid money for securing job, comma, has been granted pre-arrest bail by a coordinate bench on February 17, 2025. Stop. Apart from the fact that that person is a lady, comma, the petitioner and that person seem to be similarly circumstanced. Paragraph, on an overall assessment of the material on record, comma, I am of the opinion that
Lordship, my objection.
Yes, yes. Taraji Lekho, learned advocate for the state strongly opposes the prayer for anticipatory bail. Stop. He says that the petitioner is a part of organized crime. Stop.
He released the, they tampered the evidence, which is very much.
If released money, he is not
He
in
got
custody.
Bail, Lordships. 438 Lordships, after getting bail,
paragraph. To my query as to whether or not the petitioner has criminal antecedents, comma, learned state advocate fairly submitted that there is no such history. Stop. Paragraph on an overall assessment of the material on record and considering the nature and gravity of the alleged offense, comma, I am of the opinion that immediate custodial interrogation of the petitioner may not be necessary so long as he fully cooperates with the investigating officer. করে দিয়ে দাও। Within 7 days, he will go and meet the investigating officer. যেটা additional,
Until charge sheet has been filed.
আর তারপরে every 14 days and as and when called for. আর এটা automatic cancellation টা থাকবে। 438 এখন 438 তো নয়। হ্যাঁ, 482 হ্যাঁ।
13.
I'm for the petition. My lord, allegation is under section 447, 188, 379 and 411 of Indian Penal Code and under section 11 subsection 1 clause 3 of Prevention to Cruelty Act, Prevention of Cruelty to Animal Act 1960. My lord, the petitioners are the Indian citizens and resident of Indo-Bangladesh border area. Lord, my lord, the present case initiated against the present petitioners totally out of suspicion, my lord. My lord, the article which was seized not from the conscious positions of the present petitioners. And my lord, previously there was no any criminal incident against the present petitioners, my lord.
Yes, madam. What is it? What is the incident?
Lordship, recovery of kettles were made by the BSF officer.
Recovery of
Kettle. Kettle,
cattle.
yes, Lordship.
Oh, cattle. Recovery of
Yes,
cattle. Yes, yes.
And sleep of kettle recovery is in page 6, Lordship. And even photographs are there in page 4 and 5, Lordship. And Lordship, these are the kettles. Not submitted.
Smuggling of cattle. Smuggling of cattle.
379 is there,
379, Lordship.
theft of cattle. And
No,
prevention
no.
of cruelty to animals act, that is there, but
No, I feel very strongly about cruelty to animals. Yes. I am not going to grant you.
My lord, cattle was not seized from the conscious positions of the
Yes,
present
what is the
petitioners, my lord.
material against them? Show me, show me, show me. Get it out. How have you implicated them?
Lordship, 161 statements is in page 9, Lordship. I'm telling you.
Kalipodo Roy and Bhagavan Roy.
Lordship, this is the 161 statement, Lordship.
Is there a Caesar list?
Caesar list is there.
Caesar
That
list
is in
names
page number
names.
9.
Page 16, Lordship, is the list. And even photographs of fence cutting is there, Lordship, in page 4 and 5, Lordship.
Huh?
Photographs of fence cutting, Lordship, it's there in CD page 4 and 5.
Are they cutting the fence? Is their photograph? How have you implicated these petitioners,
Lordship,
madam?
161, Lordship, it is clearly written, Lordship, in 161.
Where's the Caesar list?
Lordship, it is in page 16, Lordship.
Yes, sure. No, sir. You have been implicated by the witnesses. The charge is of smuggling of cattle. Stop. The petitioners say that they have been falsely implicated. Stop. They are not involved in the alleged offense at all. Stop. The seizure was not from them. Stop. They pray for anticipatory bail. Paragraph. Learned State Advocate draws my attention to statements of witnesses recorded under Section 161 CRPC. Stop. More than one witness, no, several witnesses have implicated these two petitioners by name. Stop. It appears that the petitioners are part of a organized crime of cattle smuggling across the border. Stop. This is a serious offense. Stop. Paragraph. I am not inclined to entertain. The investigation is going on.
But charge sheet is not submitted, Lordship.
That's right. So investigation is going on. Now, I am told that paragraph investigation is still in progress and charge sheet is yet to be filed. Stop. Paragraph. In view of the material on record and the nature of the crime, comma, I am not inclined to entertain the petitioner's essay for apostrophe prayer for anticipatory bail. Yes.
An allegation, my lord, earlier it will be 363, 365, now it was 137, 140, my lord, allegation of kidnapping, my lord, victim girl was recovered, my lord, charge sheet submitted. And my lord, all other on.
164 statement is that other co-accused was
Of
granted
164 off?
of the victim, lordship. When I came back from tuition, she was going home, the accused person forcefully took her into a car and tried to molest her, lordship. Then the accused took her to the uncle's house.
Go and surrender. Issue. The petitioner says that he has been falsely implicated. Stop. He has no role to play in the alleged offense of kidnapping. Stop. He prays for anticipatory bail. Stop. Charge sheet.
Charge sheet filed, lordship.
Stop. Paragraph. Learned State Council shows me the statement of the victim girl recorded under Section 164 CRPC. Stop. She squarely implicates this petitioner as the person who kidnapped her. Stop. Paragraph. In view of the nature and gravity of the offense, comma, I am not inclined to extend the privilege of anticipatory bail to the petitioner. Yes.
Lord, I'm for the de facto complaint.
I am for the state, your lordship.
Yes. After 12 years of time.
15. 15.
Lord, I'm sorry. I mean, item number 6.
498A. 330 to 302.
All relative, marriage sister in law, and one is child, and another is father in law. This person, 12 years of marriage, husband before, husband taken to hospital, husband in hospital. All are in after 12 years of marriage.
Yes,
Madam, demanding more dowry, he was tortured physically and mentally. The statement of the neighbor under section 161 is there, my lord.
that will be omnibus allegations, sir.
Your statement is there, my lord.
Now,
They are the closed door neighbor.
page, acha.
Page, my lord, 9 and 10.
PM report, what does it say?
Yes, my lord.
How did she
Uh,
die?
PM
Burn injury.
Yet to be collected, my lord. Injury bedded ticket is there, my lord, at page 43.
PM report is yet to be collected.
Yes, my lord, is the case of just January 20.
January now, April, my lord.
We are in April.
Yes,
Huh?
yes, my lord.
Very strange.
If your lordship kindly consider the page 43 and 47, my lord. 90% burn injury is there. The injury is very grievous. Nature of injury is grievous. This is the very initial stage of investigation, my lord.
All are discussed, my lord.
Charge sheet not filed.
Yes,
Filed or not filed?
not fine.
Yes, 90%. All over body surface.
Yes, my lord. The burn injuries, nature of burn injury is very grievous.
Issue. Who's the married sister? Petition number 1.
Kindly see the affair. In submission, kindly see the affair. Affair says my husband informed the relative, my lord. Affair says also, my lord.
And they fled away from the hospital, my lord.
Who is
It
number
is also there.
Who is number 2?
Petition number 2 is my sister, father in
Ja.
Ja.
Ja lives in the same house. Not same house. And married daughter? Differently. 3 is the father-in-law. And what is the age of the father-in-law?
Pradhan
69, my lord. And she's a government servant, my lord.
We may be anything.
All are resident of Pradhan Nagar.
All
All
are
are resident of Pradhan Nagar.
not the same house. Married daughter.
Not them, my lord.
Same house, but
Not
Uh,
them, but
The petitioner number 1 is
same local.
the victim's husband's sister who is married. Stop. The petitioner number 2 is the sister-in-law of the victim lady. Stop. The petitioner number 3 is the father-in-law of the victim lady. Paragraph. The petitioners say that they have been falsely implicated. Stop. The incident was an accident by which the victim caught fire and succumbed to the burn injury. Stop. It was the victim's husband who took her to the hospital. Stop. The petitioners are ready, willing and prepared to cooperate with the investigating officer. Stop. They pray for anticipatory bail. Paragraph. Learned State Council opposes the prayer and draws my attention to the material in the case diary. Stop. I have seen the hospital, what is it?
Yes, ma'am.
Hospital bed
Bedheaded ticket, ma'am.
head ticket, which shows that the victim lady sustained 90% burn injury, to which she succumbed subsequently. Stop. I've also seen the statements of witnesses who are neighbors, comma, recorded under section 161 CRPC. Stop. There are allegations of torture having been meted out to the victim lady. Stop. Paragraph. Considering that the petitioner number 1 and the petitioner number 2 reside not in the same house where the victim resided and are ladies and housewives, comma, I am of the opinion that their immediate custodial interrogation may not be necessary. Stop. Hence, I allow this application insofar as the petitioner numbers 1 and 2 are concerned. Paragraph. However, insofar as the petitioner number 3 is concerned, comma, I am not concerned, comma, considering that the investigation is in progress and he is the father-in-law of the victim lady and resided in the same house, comma, I am not inclined to allow his prayer for anticipatory bail. Stop. This application is dismissed insofar as the petitioner number 3 is concerned and allowed insofar as the accordingly.
I'm grateful to your lordship.
2,
Adding section 300.
ওটা করে দিও, leave is granted to correct the cause title of the petition for anticipatory bail.
I'm a defect.
Section 16.
I'm for the defect.
Also, application rejected on 20th of January of this year. That the petitioner who is one of the active persons, he resides in Kerala. And madam, he is working in a private company named as Asset Home Private Limited. But I am taking the ground of alibi, which has not been, my lord, raised at the time of rejection of the earlier application. Therefore, the question of alibi, my lord, was not considered very naturally, lordship. Now, lordship, kindly comes to the written complaint where your lordship said that the alleged incident took place of 25th of September 2024. Lordship kindly consider page 36. On page 14 onwards, these are the bank statement of the federal bank where, my lord, the petitioner's wages were deposited. That is, my lord, at Kerala. Now, lordship kindly comes to page 95 and extend 3. Lordship, these are the evidence register of the petitioner, my lord, where he is working as a, my lord, as an employee, lordship. Page 36, your lordship kindly come. Lordship kindly see the first part, Tuesday, Wednesday. Lordship has got it. Page 36. 25/9 of 2024. He was there, my lord, his site is there in the attendance register. Not only on that day, my lord, before that day and after that day, my lord, he was altogether reside there at Kerala. So, my lord, my submissions before your lordship is this: he was not even, my lord, in the, my lord, was a participant of the alleged occurrence. My lord, on that ground, my lord, I am seeking anticipatory bail at any ground, at any condition, lordship.
My lord, these documents, my lord, were never supplied to the investigating agency first. So the veracity and genuineness of the documents has to be checked. Second thing, my lord, after rejection of the previous.
You're the state.
I am for the de facto complaint. My lord, after rejection of the previous anticipatory bail application, my lord, a complaint has been filed by the de facto complainant herself that this petitioner, along with the others, my lord, they are forcing the de facto complaint, threatening to withdraw the case and to give favorable statements before the police so that they can get a anticipatory bail.
What is the nature of charge?
Lord, gang rape, 376.
Gang rape.
Now, my lord, after that, my lord, lodging the complaint, since we have found that police is not arresting them, my lord, we have filed a writ petition before this honorable court. But since the copy of the charge sheet was not included in the writ petition, my lord, we have withdrawn the application with liberty to file afresh. My lord, I'll place the complaint before your lordship, very specific, 3rd March 2025. But this is my copy of the writ petition, my lord. Just, my lord, may peruse the written complaint, subsequent written complaint, my lord, where there is allegation of threat and withdrawal of the complaint.
You state. State.
Yes, Mr. This is the 161 statement of the victim lady.
164.
Moreover, your lordship kindly consider the 161 statement of the husband of the victim lady, page 6 now.
Page.
Page 6, the 161 statement of the husband of the victim lady.
One 161 of the victim lady.
Victim,
Oh, page 6.
page 5 victim lady and page 6 of the husband of the victim. And page 21 and 22, the mother-in-law and the father-in-law
Necessary at this stage. Yes.
deciding the same house.
You've missed the bus. You should have done that before. Issue.
Writ petition not be generated.
Genuinity of the document, police will, my lord, if it is found genuine, then lordship, I have the case, lordship, that chance may kindly be given. to the-
Come back with a better case, madam. We'll consider. The petitioner renews his prayer for anticipatory bail, which was rejected by a coordinate bench on January 20, 2025 in CRM bracket A 947 of 2024. Paragraph. The petitioner says that on the earlier occasion, his learned advocate did not take the point of alibi. Stop. On the date of the alleged offense, he was in Kerala where he works. Stop. The petitioner produces certain documents, produces Xerox copies of certain documents along with the petition petition, in support of his contention. Paragraph. Learned State Council draws my attention to the material in the case diary. Stop. The allegation is of gang rape. Stop. I have seen the victim lady's statements recorded under sections 161 and 164 CRPC. Stop. They corroborate each other. Stop. I have also seen the statement of the victim lady's husband recorded under section 161 CRPC. Stop. The statements clearly implicate the petitioner. Paragraph. Learned counsel for the de facto complainant,
Yes.
says that after this complaint was lodged, the petitioner,
Yes, petitioner along with other persons.
along with other accused persons, are threatening the de facto complainant to withdraw the complaint. Stop. Therefore, a second complaint has been lodged. Stop. Paragraph. Since I find prima facie strong incriminating material against this petitioner, and since the veracity, the authenticity of the documents produced with the petition is yet to be tested, comma, I am not, and considering the nature and gravity of the alleged offense, comma, I am not inclined to entertain the petitioner's prayer for anticipatory bail.
Grateful.
Yes, time for the state evil.
Yes.
All our family members, why cross complaint?
What are these sections?
376 by 500. Main allegation that allegation that she was tried to attempt to this is the allegation. And this alleged incident on 24 by 2024 in the written complaint. This affair was lost on 1st of December 2024.
July was the incident and December.
A charge sheet submitted, all our family member minor, this is purely matrimonial dispute. How are you implicated in this way?
Anybody in custody or all or on bail? Regular bail? Husband?
Husband allegation.
Serious allegation against the petitioner is there, my lord. 161 statement.
FIR
As
after
well
6
as-
months.
Yes,
6 months.
I have any.
yes.
I have any.
And the statement, victim,
Statement of the victim is there, my lord. Last,
this one.
this is 161 statement.
Now, where's the victim statement?
Yes. I have already.
Folded.
Folded, already folded. Last one.
Issue. There is no such incriminating material. The petitioner says that the incident is the outcome of a matrimonial dispute. Stop. The petitioner is the father-in-law of the de facto complainant oblique victim. Stop. The allegation is that the allegation is under section 498 capital A and 376.
All are DNS.
Oh, thought about it.
Corresponding section 498A, corresponding IPC.
The
509.
allegation is of torture and attempted rape. Stop. He says that he has been falsely implicated. Stop. He is prepared to cooperate with the police in all respects. Stop. All other accused persons, including the victim's husband, are on anticipatory bail. Paragraph. Learned State Counsel, comma, while opposing the prayer, comma, draws my attention to the victim lady's statement recorded under section 164 CRPC. Stop. I have also considered the other material in the case diary. Stop. Paragraph on an overall assessment of the material on record and charge sheet file. And seeing that charge sheet has already been filed, comma, I am of the view that immediate custodial detention of the petitioner may not be necessary. Comma, so long as he cooperates with further investigation, comma, if any. Usual করে দিও, affidavit of service. Service affected. তাহলে পড়াতে বলে দিও, affidavit of service, হ্যাঁ? In spite of service, nobody appears for the de facto complainant oblique victim.
I'm grateful to you.
After the state lordship.
That has been brought under section 147, 420, 506 and 34 of the Indian Penal Code. But apart from the prosecution story, my lord, the actual fact remains that, my lord, the petitioner was firstly induced by one Rakesh Kumar Singh that a property is about to be sold. My lord, I visited the property, having been interested, my lord, I interacted with the owner of the property. Our agreement for sale was not executed. I handed over a few cash consideration money, and thereafter, my lord, a deed of sale was executed. With the intervention of that person, is the middleman Rakesh Kumar Singh. He became one of the eyewitness in the sale of it. But I took a financial loan from a financial company. Loan was accordingly sanctioned. The entire money was transferred in favor of the owner of the property. But as soon as the deed was executed, I was about to take the possession of the property. As soon as I entered into the property, I was obstructed, I was assaulted, I was not permitted to take the possession of the property. Thereafter, a chaotic situation arises. The financial company proceeded under the Surface Act. The possession was taken, Surface Act proceedings was taken, and thereafter, after almost 6 months, the owner of the property, the owner of that flat, filed a complaint against him. And before that, I also filed a complaint against the owner as well as that middleman whom induced me to file.
Yes, sir. This is a civil dispute.
Civil dispute.
Yes.
There is a permission for cancellations of the deed. Cancellations, they said that they transferred.
Whatever the cancellation, this is the issue.
My objections.
Yes, yes. The petitioner says that the dispute between her and the de facto complainant is purely civil in nature. Stop. It pertains to sale of a property by the de facto complainant to her. Stop. The bank from which loan was obtained has now proceeded against the property under the Surface Act. Stop. She prays for anticipatory bail. Paragraph. Learned State Counsel opposes the prayer. Stop. He draws my attention to the material in the case diary. Paragraph. I find that the dispute between the de facto complainant and the petitioner is indeed civil in nature. Stop. On an overall assessment of the material on record and the possible extent of complicity of the petitioner in the alleged offense, and considering that she is a lady, she's a housewife, no?
Housewife.
She is a lady and a housewife, comma, I am of the view that immediate custodial interrogation of the petitioner, charge sheet,
Not filed.
is not necessary so long as she cooperates with the investigating officer.
But she meet the fortnight at the daytime.
Lady,
They did a time, your lordship.
Lady will meet the Ayog.
Something.
When she is called for by the Ayog,
Lordship,
she will
lordship.
go. As in when called for.
Lordship.
Yes,
My lord, one humble request, my lord. My lord,
yes.
I have just, my lord, received the case diary. Can it be a short passover, my lord? Let me go through the case diary.
My lord, I have got the statement.
21,
All other, my lord, law, is to, my lord, verify the law. For interest of anticipatory bail by the court in the range of There was a earlier rejection, my lord. In this petitioner, that was, my lord, the charge sheet stage, my lord. This instant application has been filed, my lord, after charge sheet has been filed.
body was recovered from the pond.
From the pond, my lord. And thereafter, my lord, immediately after the, my lord, the victim lady got missing, my lord. Missing diary was lost. It was lost by the husband itself. And my lord, the husband was not present, my lord, at the place of occurrence, because she, my lord, the victim lady went to attend, my lord, ceremony, outside of her, my lord, matrimonial home. And there, my lord, she went for a, my lord, natural call, my lord, and my lord, she.
Yes, Dr. Chaudhary.
My lord, prima facie, there are my lord incriminating materials against the petitioner. My lord, may kindly see the 164 statement of the brother of the deceased lady. My lord, he has clearly implicated this petitioner. My lord, the dead body was recovered from the pond.
Page.
Page, my lord, is page 51, my lord.
No, but was the petitioner present at that place? He was not present.
My lord, but it was recovered from the pond which is nearby to the house of the sister-in-law. Sister-in-law, my lord, this honorable court presiding over by your lordship and by Justice Chaudhary, my lord, has rejected the bail application of this petitioner and granted anticipatory bail to the other family members.
Rejected the bail application
Yes, sorry, anticipatory bail. Anticipatory bail application.
of this petitioner.
Of this petitioner. This petition.
Then why are you renewing your prayer? Why are you renewing your prayer?
My lord, that was rejected, my lord, when my lord, the charge sheet was not filed.
Yes.
Investigation was going on. Now, my lord, the charge sheet has been filed. After that, my lord, this incident.
Charge sheet has been filed. It had to be filed. You are absconding. What can be done? No,
My lord, it was, my lord, it was before filing of the charge sheet. When
doesn't
the-
matter.
This petitioner's bail was, my lord, rejected.
Yes, you have successfully evaded the police till now. You have successfully evaded the police. Now go and surrender or abscond forever. When they catch you, they will be in jail. Hey, show. No.
This is, my lord, at the spot. my
No,
lord.
no.
The incident took place, my lord, outside of the matrimonial home. And my lord, immediately after, my lord, she got missing. Before the husband filed a, my lord, missing diary. So kindly consider, my lord.
Yes, clever husband.
Yes,
Clever husband.
kindly consider, my lord.
Zafar Alam. The petitioner's prayer for anticipatory bail was rejected by uh, a division bench on November 6, 2024 in CRM A 748 of 2024. Stop. The prayer of other family members of the petitioner was allowed. Stop. Paragraph. The petitioner renews his prayer for anticipatory bail, saying that at the time of rejection of his earlier prayer, charge sheet was not on record. Stop. Now, charge sheet has been filed. Stop. Therefore, he should be granted pre-arrest bail. Paragraph. The earlier bail prayer of the petitioner was anticipatory bail prayer was rejected on the ground that there is sufficient prima facie incriminating material against him. Stop. He has successfully evaded the police till date. Stop. I am not inclined to entertain his prayer for anticipatory bail.
If I will made a clear note that they be considered.
Where? Prayer for anticipatory bail? No, that would
Yes,
influence the court.
yes.
That would influence.
The court of law will consider that in accordance with law.
Yes, the court is bound to do it.
Yes.
If you are entitled to pray for anticipatory bail, the court is bound to do it. No, you are a very clever husband. Sure, next.
Great.
22.
I'm for the state.
E26.
Political rivalry, attending, from returning from Bodhar house, there are for the victim assaulted.
Yes, what is the nature of injury?
Lordship, the nature of injury is grievous, and this accused petitioner, actually inflicted.
4 petitioners.
The accused petitioner Motabel Mia Hamid, all are yes. Injury is incised wound 5 inch into 0.5 inch, head injury, grievous hurt, and all are named in FIR, and all the independent witness named them.
Any overt act?
Yes, Motabel Mia inflicted injury with on the head of the victim, and Hamid also inflicted the injury.
When? Where? Head?
Head.
Both head?
Both head. Page number 9, 10 and 11 are the 180 statement of BNSS, corresponding 161 statement of the independent witnesses, and the charge sheet is still pending. Lordship.
What about 3 and 4?
Mustafa is also involved.
Overt act? No overt act.
Lordship, one second.
Political rivalry.
Just page 90.
Political group, my lord. Coming from Bodhar house, there are allegation remained in 26, my lord. I will cooperate with the
Charge sheet?
These three accused petitioner number 1, accused petitioner number 2, and accused petitioner number 4, all actually inflicted the injuries. And no overt act has been mentioned regarding accused petitioner number 3.
Why do you need custody? If they cooperate? Tell me.
Lordship, actually,
Political rivalry? How case and counter case? Why do you need custody?
Lordship, assessment is absolutely correct. But one thing, Lordship, this is a grievous injury.
Yes.
This is a grievous injury, and after causing the grievous injury, if they get the benefit of anticipatory bail. This is not a post-arrest bail. This is an anticipatory bail. So it will be a habit that we will inflict such type of injuries and we'll get anticipatory bail.
Issue. We'll allow, the 4 also we didn't.
No overt act against a
4.
petition number 3. 1, 2, and 4. 1, 2, and
4 where will I get overtact?
9, page number 9.
Liability, there must be a specification, my lord, he belongs from the particular political party, my lord, there must be, my lord. They will specifically name,
It has been stated.
my lord, complaint by the political motivated complaint, my lord. Will forward is the investigation. my lord.
The statement of the witnesses are not of the
Like murder of, allegation of previous murder.
inflicting injury on the head. Inflicting injury on the head is actually 100 after filing of charge sheet. Certainly 109 will be attracted. That is attempt to murder.
They are adding section of. Will forward, my lord. Your lordship, some Indian condition will abide.
No, Hamid, Mustafa Ali.
You see, lordship, মোতাবের লোহার রড দিয়ে মারলো.
That's right.
That's right. হামিদও মারলো.
Hmm?
হামিদ মিয়া. Last para.
Hamid কোথায় মারলো? হামিদ কোথায় মারলো?
মোতাবেল মারলো, হামিদ ধরলো।
মোতাবিল মিয়া লোহার রড দিয়ে তালেমা বিবির মাথায় আঘাত করে। ইহার ফলে তালেমা বিবি রক্তাক্ত জখম হয়ে মাটিতে লুটিয়ে পড়ে ও জ্ঞান হারায়। আমরা তখন তালেমা বিবিকে সামথিং হাসপাতালে নিয়ে যাই। সেখানে ডাক্তারবাবু তালেমা বিবির মাথায় 5টি সেলাই করে ও দিনহাটা মহকুমা হাসপাতালে পাঠিয়ে দেয়। তালিমা বিবি দিনহাটা হাসপাতালে তখন ভর্তি আছে ও চিকিৎসা চলছে। মোতাবের মিনচা, হামিদ মিনচা, মোমেন বিবি ও মোস্তাকিম মিনচা এরা দুষ্কৃতিকারী বলেই গ্রামে পরিচিত। They have a bad reputation. That is what the statement is.
Specific allegation against মোতাবেল.
Yes. Hey, the petitioners say that the complaint arises out of a political rivalry. Stop. The allegations are false. Stop. They are prepared to cooperate with the investigating officer. Stop. They pray for anticipatory bail. Paragraph. Learned State Council, while opposing the prayer, draws my attention to statements of witnesses recorded under section 161.
180. Now
180.
180 of BNSS.
BNSS. Stop. I find that specific overt act has been attributed to the petitioner number 1, who apparently struck the victim on the head with an iron rod. Stop. The injury report says that the injury is grievous. Stop. However, no overt act has been attributed to the other petitioners. Paragraph. In view of the aforesaid, I am inclined to allow the anticipatory bail prayer of the petitioner numbers 2, 3, and 4. Stop. The prayer of the petition number 1 is rejected. 2, 3, and 4 the other.
Lucky 1 in judges. Petitioner number 2 and 4 should meet the IO at least once in fortnight.
Yes, 2 and 4 once a fortnight.
Much.
আর একটা দিয়ে দেবে ফার্স্ট প্রথম 7 দিনের ভেতরে প্রত্যেকটা দিয়ে দেবে within 7 days they should surrender কথা লিখুন না, go and meet the IO. Once you have obtained anticipatory bail, you should go and meet the IO. First meeting will be within 7 days, and then
I'm
Once every fortnight, this is in every case I am saying. Once every fortnight and as and when called for. এটা সবাইকে বলে দিও তো।
23 আছে
one joint from the arms from the command from his house and he said from me but if they are on the foundation
No seizure from you.
for granted fail for my instructions.
Yes, Mr. Chakravarti.
Charge is pending. Jayanto Borua was arrested with firearms on the leading statement of one Pradeep Go. Jayanto Burma stated that I have received the goods from this petition.
Before the police. And Jayanto is on bail.
Jayanto is. Order.
Esho. The petitioner says that no arms was seized from him. Stop. He has been implicated solely on the basis of one Jayanto what? Borua, from whom arms were seized by the police. Stop. Jayanto is now on bail. Paragraph. Learned State Council says that investigation is in progress. Stop. However, he admits that there was no seizure from the petitioner herein. Stop. I therefore see paragraph. I therefore see that there was no seizure from this petitioner. Stop. His implication is based solely on statement made by a co-accused person before the police, which may not be admissible in evidence. Stop. Paragraph. Hence, I am inclined to allow the petitioner's prayer for anticipatory bail so long as he cooperates with the investigating officer. Co-accused? No, witness.
109 bottles of codeine phosphate triodine hydrochloride syrup was recovered
From whom?
from accused person, but he managed to lure. Lordship,
Allegation is that
Lordship.
information that one person was selling some cough syrup in the local. As per the information, police went to the spot and was source identified, but this that person was straight away and subsequently during inquiry, petitioner name has been covered.
I think it's number 2, Lordship.
These witnesses are not co-accused persons.
Lordship, local witnesses are there, Lordship, in page 8 and 9, Lordship.
The Hinur Hawk.
Lordship.
Yes. The petitioner says that there was no recovery from him. No recovery of narcotics from him. He has been implicated on the basis of statements made by witnesses. Stop. He is willing to cooperate with the investigating officer. Stop. He is praised for pre-arrest bail. Paragraph. Learned State Advocate draws my attention to statements of witnesses recorded under section 161 CRPC. Stop. The statements are to the effect that upon seeing the police, comma, the petitioner fled, leaving behind the narcotics. Stop. Paragraph, I therefore see prima facie involvement of the petitioner in the alleged crime. Stop. Keeping in mind the restrictions in section 37 of the NDPS Act and seeing that commercial quantity of contraband items is involved, comma, I am not inclined to allow the petitioner's prayer for anticipatory bail. Passover or what?
Saurabh Ganguly is there, he's on his way. Passover, huh?
27.
State.
Yes.
126 subsection 170 subsection 200 like C5 of the all the non-available section 100 like
307.
Lordship, this is the injury report, Lordship.
But what if I had laws against two accused persons and one accused person granted and by the market citizen. But agitation is that part.
Does not appear to be serious, does not appear to be grievous. What is the incident? What happened?
The informant for electricity card at the border area. But when he returned back at that time, returned back to the home, subsequently the PSF personnel took mobile phone of this petitioner. And this petitioner suspect that this informant had said something to the PSF for that reason, the PSF person had took his mobile phone. And thereafter, there was a fighting between the mother. That is the reason.
This petitioner gives some information to the BSF and BSF.
The petitioner says that the incident occurred when a BSF personnel at the Indo-Bangla border seized the petitioner's mobile phone. Stopped. The petitioner was under the impression that the de facto complainant had
Said something about
complained to that BSF personnel about this petitioner, and therefore his phone was confiscated. Stop. From this, there was an altercation between the de facto complainant and the petitioner, which may have resulted in injury to the de facto complainant. Stop. Paragraph, the petitioner prays for rearrest bail. Stop. It says that he will fully cooperate with the investigating officer. Charge sheet not filed. Paragraph. ওখান থেকে add করে দাও আগেরটাতেই। He further says that a co-accused person has been granted anticipatory bail by the learned Sessions Court. Paragraph, learned State Council shows me the injury report. Stop. The injury does not appear to be grievous. Stop. Paragraph, on an overall assessment of the material on record and the nature and gravity of the alleged offense, comma, I am of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the investigating officer. ঘুরে এসছি। 5 minutes. Tomorrow, Monday. Petitioner is also not, is a petitioner, not today. Yes, what is the material against these two?
They are all. And 161 statement, their name has been.
Everybody has been named. The others have been granted and charge sheet filed. Issue. Husband has been granted bail. The petitioners are the uncle-in-law and aunt-in-law of the victim lady. Stop. The charge is under sections 498 capital A oblique 304 capital B oblique 34 IPC. Stop. The petitioners paragraph. The petitioners say that all other accused persons who are the other family members have been granted anticipatory bail by this court, and the husband of the victim lady has been enlarged on bail by the learned trial court. Stop. They have no involvement in the alleged crime. Stop. They will cooperate with the police whenever necessary. Stop. Paragraph. Learned State Counsel, while opposing the prayer, draws to my attention the statements of witnesses recorded under 161, section 161 CRPC. Stop. The statements as well as the first information report name all the accused persons. Stop. Paragraph. In view of the fact that no specific overt act is attributed to these petitioners and the other accused persons who appear to be similarly circumstanced, have been granted bail, anticipatory bail, oblique bail, and also seeing that charge sheet has been filed, I am of the view that immediate custodial detention of the petitioners is not necessary. Custodial interrogation, the petitioners is not necessary. Or a petitioner, that the usual condition আছে, petitioner number 1 will report to the investigating officer once a fortnight. 2 নয় কিন্তু, হ্যাঁ, কিন্তু একবার এই bail power within 7 days, both the petitioners will report once to the IO, investigating officer. তারপরে petitioner number 1 every fortnight, and as and when called for.
I'm grateful to you, Lordship.
One or back expert part.
regarding cattle smuggling from India to Bangladesh. As the petitioner is the Indian national, has no previous incident about that.
The Indian national, where is your evidence? What have you annexed? What have you annexed? ID, EPIC card. You've not annexed to the petition. Vicky? What is this? What is this? Aadhaar. Aadhaar. You have annexed only the Aadhaar. Verify authenticity.
Lordship, as per investigation, also this petitioner is Indian citizen.
Indian. Oh, I see.
In formal affair, charge sheet all. Kuchli bari.
Then what is the material against him?
That the associates to smuggle the cattle to Bangladesh.
Independent witness or co-accused persons?
No,
Whose
they are-
statement?
Co-accused statement and other witness, they are also stated that they are smuggling the cattle. But the Bangladesh national, they are fled away.
We understand. Have they named Amol Rai?
Amol Rai.
See. Amol Rai's name appears in the statements.
On the statement of the co-accused.
Co-accused before the police, that is not admissible. Anyway, charge sheet has been filed.
Yes, sir. That's it.
Yeah. The petitioner says that he is an Indian national. Stop. He has been falsely implicated in this case of alleged cattle smuggling across the Indo-Bangla border. Stop. There was no seizure from him. Stop. Seizure. SEIZURE. From him. Stop. His name has been included only on the basis of statements made by co-accused persons before the police. Stop. He prays for anticipatory bail. Paragraph. Learned State Counsel, while opposing the prayer, says that investigation has revealed that the petitioner is indeed an Indian national. Stop. However, statements of co-accused persons have implicated him as a participant in cattle smuggling, in the offense of cattle smuggling, Stop. Paragraph. Statements of co-accused persons recorded by the police may not be admissible in evidence. Stop. No statement of any independent witness would be shown to me, implicating this petitioner. Stop. I further see that charge sheet has already been submitted. Paragraph. In view of the aforesaid, I am of the opinion that immediate custodial detention of the petitioner is not necessary. Accordingly, within 7 days, meet korbe. Are you okay? Huh?
I'm for the state CD producer.
I am for the state in item number 35. Did you?
नहीं चलो. Next.
38.
Next.
39.
39 state. 1 day, not today. 39.
Monday. Okay, Lordship. Monday, Lordship, 39.
39 Monday. Monday.
40,
Next.
41,
Next.
42,
Next.
43,
Next.
44.
And I am for the petitioner, in 376 case, I have started the notice, but it was not vested. Right? Direct the.
Who is appealing for the state? What, 44?
Kollola is there.
So I'll direct the state to effect service. You can give his name, you can give his name. Learned advocate for the petitioner says that attempted service of this petition for anticipatory bail on the de facto complainant oblique victim has failed. Stop. Paragraph. Let the state effect service and file a service report on the next date. Stop. The report, the notice. Oh, you are appealing. You said you have not served.
It's not necessary to.
Then state is not here. Not to do.
Service is not required.
Yes, no, because he's appearing. Lekho, although the petitioner says that attempted service on the de facto complainant oblique victim has failed, comma, learned advocate appears for the de facto complainant oblique victim. Paragraph. On the prayer made on behalf of the state, let this matter stand adjourned for the day. Not today only.
Grateful.
45, my lord, I am for the petitioner. My lord, Mr. Sarkar. What is this? My lord, the case arises out of a partnership agreement between two partners. My lord, the agreement also, my lord, includes the arbitration clause that if any differences between the partners with respect to the affairs of the firm, my lord, that has to be referred to arbitration. Now, my lord, the issue in crux is that the complainant, she is one of the partner. She had paid a sum of 25 lakhs to enter into the partnership. My lord, the business was earlier to the partnership, it was a sole proprietorship business
Of the petition.
of the petition. Thereafter, the de facto came in, my lord, during COVID.
The de facto is a lady or a
De
man?
facto is a lady and petitioner is also a lady. Now, my lord, during COVID times, she was facing financial crunch, business was not running. So after that, she accepted the partnership and a new partnership firm was constituted. 25 lakhs payment was given as a security deposit, not as an investment, but as a security deposit, on a condition that the money has to be refunded back after the firm gains profit. Now, thereafter, since even after the partnership, the business is still facing losses. So, she could not repay the entire money. She has given a substantial portion of the sum, 2-3 lakh rupees, and there was an agreement, an arrangement between the parties that the payment they will
Mr.
slowly.
Ganguly, where is the criminality here?
Lordship.
Prima facie, entirely civil.
So the brief was alluded to the advocate, but he is busy on his leg, so he gave me the same. Lordship, indeed, the de facto complaint and the accused person entered into an agreement, partnership, deed of partnership is here, where 36% share was allocated to the de facto complainant. But the allegation is that, the twofold allegation is that
For 420, what is the charge?
420, yes, 420.
without disposing her 36%, they have sold the entire.
Go and file a suit.
Another thing is the Lordship, page 54. Page 54.
Charge sheet filed.
No, investigation is going on, my lord. But I'll cooperate with this.
So in page 54. What has been noted by the other local accused, what could you say?
This Undira Bhattacharya is
He is the de facto complainant.
Another is Lordship, page 42. 42, that transaction of 36% share.
issue. The petitioner says that that there is no criminal angle to this dispute between to the present dispute between the de facto complainant and the petitioner. Stop. The de facto complainant had deposited rupees 36 lakhs,
25 lakhs.
25 lakhs with the partnership firm which was constituted by the petitioner and the de facto complainant. Stop. The understanding was that the money will be returned to the money will be treated as security deposit and will be returned to the, this is what he says, she says, to the de facto complainant. Stop. However, comma, since the business of the firm is suffering loss, comma, the entire money could not be returned. Stop. Hence, this complaint has been lodged. Paragraph. Learned State Council draws my attention to the partnership deed constituted by and between the partnership deed executed by and between the de facto complainant and the petitioner. Stop. He also shows me statements of witnesses recorded under section 161 CRPC. Stop. Apparently, two persons threatened the de facto complainant on behalf of the petitioner. Requiring her to withdraw the criminal complaint. Stop.
Rupees 25 lakh was given for development of the business, not security deposit.
It's what he says.
But the deed says so.
Whatever it is, it's go to the civil court, let them sort it out.
It says security deposit.
Stop. However, it does not appear that any complaint has been lodged in that regard. Has any complaint been lodged regarding this threatening?
No, my lord, I do not have any information.
However, no, it appears that no complaint has been lodged regarding such alleged threat. Stop. Paragraph. Paragraph. I've considered the facts and circumstances of this case. Stop. On an overall assessment of the material on record, I am of the view that this is not a case where immediate custodial interrogation of the petitioner is necessary. Paragraph hence. Necessary so long as she cooperates with the investigating officer.
Grateful, madam.
একে আর দেখা করতে পারো না মহিলা, খালি 7 দিনের ভেতরে মিট করবে একবার, and as and when called for.
But since the petitioner is a lady, so some indulgence may be given with respect to visiting the police station.
As and when called for. Within 7 days, she'll report for the first time.
Lordship.
And then as and when called for.
Lordship. Grateful.
Chalo.
I'm praying for not to deludge.
48.
40.
49.
Lordship, 49 and 50, I'm praying for short pass over.
51.
51,
Lordship, I am for the petitioner. Lordship, the case.
51 state,
Lordship, the case is initiated under section 303, subsection 2 and 317, 2, 4 and 5 of BNS. Lordship, the allegation is that one Ajit Singh used to steal bicycles and he sold that bicycle to this petitioner. This petitioner is a bona fide purchaser, Lordship. He has no knowledge about whether that was stolen or not. He has a cycle repairing shop. And it is also reflects from the record that he has a cycle repairing shop. He, in this case,
what are these receiving stolen goods?
bicycles were recovered, Lordship, and this is page 12, Lordship. In this case, he is the person who is cheated, Lordship. Cycle. And co-accused were arrested from the spot, Lordship. That Ajit Singh, who used to stole, as per the allegation, who
Partnership.
no, Lordship, he has no knowledge, Lordship.
Of course not. 28 bicycles only.
No, he has all of them
Charge sheet filed.
property, Lordship. He has a cycle repairing shop and he used to keep all the cycles which are to
Any
be
criminal
repaired.
antecedent of this person? He'll cooperate. Charge sheet filed. So he'll cooperate fully. You have seized the articles. Why custodial integration is necessary?
Lordship, in a 161 statement, page 16 and 17, it is mentioned, Lordship.
Mention, what is mentioned?
Lordship, documents are corroborating with the prosecution case, Lordship.
Yes, you're implicated by neighbors, by
Lordship, all the cycles are recovered already. There is no further chance of further recovery, Lordship. And he has no knowledge about. And
that I don't believe. That is the problem. I don't believe that he has no knowledge.
Lordship, recovery was from the house, Lordship.
Hey, so
I'm accepting
go
it,
surrender, cooperate.
Lordship,
You
kindly,
will get bail. Anybody will, in this kind of offense, you'll get bail. Cooperate, go.
recovered.
Obtain regular bail. The petitioner says that he had no idea that the bicycles that he purchased from one Ajit Singh, are all stolen. Stop. Stolen goods. Stolen goods. Stop. He is the bona fide purchaser of such bicycles. Stop. He runs a bicycle repairing shop. Stop. He says that he will cooperate with the investigating officer if granted anticipatory bail. Paragraph. Learned State Council draws my attention to statements of witnesses who are residents of the same locality, recorded under section 161 CRPC. Stop. They implicate the petitioner as an accomplice of the said Ajit Singh, who used to steal bicycles and sell them to the and deliver them to the petitioner. Stop. I see that investigation is in progress. Paragraph. In view of the prima facie incriminating material against the petitioner, I am not inclined to allow his prayer for anticipatory bail. Stop. Paragraph dismissed.
Lordship, I am for the petitioner.
Lordship, CD is not available, Lordship. One day, Lordship. Lordship 53 also.
54 petitioner name.
54, my
54.
lord. Yes. My lord, I am for the petitioner. My lord, dispute is, my lord, with respect to distribution and, my lord, partition of inherited family property. Now, my lord, against me, the allegation is that there was a hot heated altercation when the family members were present, and I tried to bite my cousin brother on his lips. That is the allegation.
Cousin brother on his?
On his lips. So, my lord, 307 is, my lord, has been included.
Injury report?
Injury report is there, Lordship, deep cut injury over lip and face. Charge sheet has already been submitted.
Sure. The petitioner says that there was a fight between family members over the issue of partition and distribution of joint property. Stop. In the process, comma, the allegation is, comma, that the petitioner bit the de facto complainant.
De facto complainant son.
Oh, the de facto complainant's son on the lips and all over the face. Stop. Paragraph. Learned advocate for the state shows me the injury report. Stop. There is no grievous injury. Stop. Investigation is complete and charge sheet has been submitted. Paragraph. In view of the aforesaid and considering the nature and gravity of the alleged offence, comma, I am of the view that immediate custodial interrogation of the petitioner is not necessary.
Grateful to you, lordship.
ওইগুলো 7 দিনের ভেতর সবাইকে বলে দিও 7 দিনের ভেতর রিপোর্ট করবে আইওর কাছে তারপরে এভরি ফর্টনাইট অ্যান্ড অ্যাজ অ্যান্ড ওয়েন কল্ড ফর দেখা করবে হ্যাঁ মহিলা না হলে
In this case, my lord, charge sheet has been submitted.
তাই তো বলেছি আমি ও তাহলে তো আইও হবে না
Before the planet trial court.
Shall attend each and every dates.
ইট অ্যান্ড এভরি হিয়ারিং তো থাকবেই সেটা করলেই হবে
হ্যাঁ।
Grateful.
শোনো চার্জশিট হয়ে গেলে তো আর আইও হবে না লোকাল ওসি যেটা ওয়ের হি রিসাইডস বলে দিও তো কারণ সব কটাতে আইও লিখে দিলে আমার বোকা উঠে
For the petitioner.
My lord, 1 day's accommodation required, my lord. No CD. Grateful.
56.
Yeah, for the petitioner.
1 day. 1 day.
57.
Lordship, I'm for the petitioner. Lordship, CD not, Lordship, 1 day. 57, 58, my lord.
50.
Receive.
59.
No petitioner. Next. Next.
61.
My lord, I'm praying for 1 day accommodation.
67.
Modifications.
67? 66, you will do it.
Lordship, he praised me to do it.
No. He prays that the modification, the wave of the Thana Hajira may kindly be waived.
That is the case.
Only their submissions.
Yeah, has he been complying with the
Yes, Lordship.
conditions?
Their conditions.
For how long? When was it granted?
Granted to November and last they have complied.
29th, 11th.
This is a case.
ওটা কি দিলে আমাকে? ও আগে ডিভিশন বেঞ্চ ছিল বলে দুটো কপি নাকি?
Granted 29th November 2024, and the condition will be the meet the investigating officer once in a week for until further orders, Lordship. I have complied it and kindly waive the conditions.
Charge sheet has been filed.
Lordship.
We will just relax this condition.
Lordship.
Hey. The petitioner was granted anticipatory bail on November 29, 2024, inter alia on the condition that he shall meet the investigating officer of the case once a week until further orders. Stop. The petitioner says that he has been scrupulously adhering to that condition. Stop. Charge sheet has now been filed. Stop. The said condition may be waived. Paragraph. Learned state advocate says that there is no adverse report as regards compliance of the conditions of anticipatory bail by the petitioner. Paragraph. In view of the aforesaid, I am inclined to and do hereby waive the condition requiring the petitioner to meet the investigating officer once a week.
As and when. No
Stop.
need.
However, now charge sheet has.
That's the Lordships.
However, if the concerned police authorities call for the petitioner for any purpose, in accordance with law, the petitioner shall attend. All other conditions of the all other conditions mentioned in the order dated November 29, 2024 shall remain unaltered.
Of my claims.
Cran. 66 holo.
66, my lord.
60-70 here.
No.
State, I am appearing on behalf of the
State.
Lordship. Mr. Ujjal Luxem was appearing yesterday, Your Lordship, and I was directed to serve him a copy because it was filed in the principal bench, Your Lordship. In this matter, Your Lordship, the order was passed.
No, but he is not there. Why are you arguing?
One day, motion, Lord.
Not today.
69.
69, Your Lordship, I am on behalf of the petitioner, Lordship.
State.
I am for the state. It's the prayer is only for the correction of the cost title.
One is cost title amendment and second is the waiver of the condition. Waiver of the condition, Lordship.
And one is correction of cost title.
Lordship.
But the order sheet has not been annexed.
Order. Yes, order dated.
The bail order has not been annexed.
কোথায় order আছে?
এখানে নেই তো।
Grand one full time. 8 at 2.
Can one টাতে দেখো?
হ্যাঁ।
তোমার যে কটা আছে? দুটো একটা।
এখানে একটা আছে cost title.
ওই তো can one টা।
Can one is this one.
No, can two that one.
এটা আমাদের।
No, এটা can one.
No, Grand one is the relaxation.
Can two is the application, amendment of the cost title.
When was the anticipatory bail granted?
On 5th on 5th March 2025.
What is wrong in the cost title?
My lord, the name of the petitioner lordship that something has to be added.
Here the name is Kuran Sarkar.
Yes.
And alias Kuntal Sarkar. Alias.
So alias you have to add. You want to add that? Esho. Cran 2 Cran 2. This is an application for leave to correct the cause title of the bail petition, of the petition for anticipatory bail, which was
Kuran Sarkar.
disposed of on March 5, 2025. So the petitioners seek to amend the cause title by adding another name of the petitioner number 1, i.e. quotation of the Kuran Sarkar alias
Kuntal Sarkar.
Kuntal Sarkar. Unquote. What?
The name of the lordship.
Similarly, comma,
Shomiran Sarkar alias
the petitioner number 2's name should be corrected as Shomiran Sarkar alias Shomish Sarkar. Paragraph. Leave is granted as prayed for. Stop. Let necessary correction be effected by learned advocate on record for the petitioners. Paragraph Cran 2 is disposed of. Next, Cran 1. Which condition you want to be relaxed? Why should be relaxed? Only 5th of March this was passed.
Yes, only 5th of March.
Too early, madam. Don't press it because I'll reject it. It's too early. Not even 1 month and you want relaxation.
ship.
Which condition?
Finally, lordship comes first petitioner.
The petitioner shall attend the concerned court on each day
Yes.
when the matter is fixed, and further condition the petitioner will not leave the jurisdiction of the concerned police station. So this is not a very stringent condition.
No.
This is not a stringent condition. From the
Correct. Don't press it, I'll reject it. No. Not after 10 minutes on this. Sorry, madam. Very well, let me reject it then. Cran 1. This is an application for relaxation of conditions of anticipatory bail which were imposed while granting anticipatory bail on March 5, 2025. Stop. The two conditions, paragraph 3, the two conditions that were imposed are that the petitioners shall attend the concerned court on each day when the matter is fixed, and that they will not leave the jurisdiction of the concerned police station without the prior leave of the investigating officer. Stop. Charge sheet has been filed.
CD has not been produced.
Stop. Paragraph. It has not even been a month since the order was passed. Stop. It is too early to seek relaxation of the conditions of anticipatory bail. Paragraph. Hence, comma, at this stage, I am not inclined to allow the prayer. Cran 1 dismissed.
Much of it.
Not today.
My lord, I am appearing on both the 2, 3, 6 and 7.
Yes.
My lord, it is not possible come tomorrow. Let me fixed on Monday.
Monday. Second call. Neonawita Vijit, usual order. Nobody appeared for the petitioner in the first call. Stop. Nobody appears in the second call either. Next. আরেকটা add করে দিও, no accommodation is sought for.
Item 3. 1 day accommodation, Rashi, 1 day. 1 day.
Not today. Six. Same as two. Same as two. Give your appearance. Nine state. Not today.
Petitioner is not present.
Petitioner was there in the first call. Just there. So not today. Thirty-six children. Same order as two. Give you're appearing 36.
For the state.
Yes, give your name.
Yeah, no.
Dismiss.
Not today, Lordship.
36.
Lordship.
Not today.
Not within London.
37.
37. Not today. 38 dismissed.
I
Same
got
as two.
state.
Give your name. Same as two.
40, Lordship, I'm paying for not.
Not today.
41.
Not today.
44.
But state is present.
Not today.
Not today.
42 also not.
Not today.
43.
But all these matters tomorrow, no further adjournment.
Forty 46 and 47 also paying for not.
Not today.
Grateful, Lordship.
49.
Paying for not today. 49 and 50 both the better.
Very well. Dismissed. Give the name if state council.
59.
60.
Dismissed.
59, 60.
55.
59, 65, 60 টা দিচ্ছি।
At least half a dozen of your matters were adjourned for the day. Where were you?
I am in court number 3. In one time, 3 court bail application for SPL TV. First time I there, but I went to court number 3. One matter, this.
Yes, what is this?
For relaxation of condition matter.
Order dated
Granted, order dated, 17/8/2020, my lord. And not to entering into the jurisdiction, my reason, my father is this, I annex the medical document, my father is a aged person, I want to reside parental house.
What is the stage of the trial?
The trial, some of the witness was examined, and not concluded, 2020.
Any adverse report regarding compliance?
Nothing.
So he wants to now,
CD is not with.
Tinata.
victim,
Police station.
victim girl has been examined.
Yes, my lord.
Victim examined, all vulnerable witnesses have been examined.
But trial not concluded.
For 5 years almost. Almost 4.5 years. Issue. The petitioner was granted anticipatory bail on August 17, 2020, inter alia on the condition that he shall not enter the jurisdiction of Dinhata Women Police Station, except for the purpose of investigating and oblique or attending court proceeding until further orders. Investigating koro na, investigation koro. Stop. Paragraph. Now, same paragraph. The petitioner now seeks relaxation of that condition. Stop. He says that he has been scrupulously adhering to the conditions of anticipatory bail. Stop. The trial has still not concluded. Stop. All the vulnerable witnesses, including the victim girl, have been examined before the learned trial court. Stop. His father is critically ill and resides in the family house within Dinhata, within the jurisdiction of Dinhata Women Police Station. Stop. He would like to visit his father and attend to him. Paragraph. Learned State Council fairly tells me that there is no adverse report.
As the CD was not with, as the CD is not with me.
Tells me that as per his instruction, there is no adverse report as regards compliance of the conditions of anticipatory bail by the petitioner. Stop. He says that he is unable to make further submission since the case diary is not available with him. Paragraph. I see that the trial is pending since 2020. Stop. There does not appear to be an early conclusion of the trial. Stop. The petitioner has been complying with the conditions of anticipatory bail for the last 4.5 years. Stop. He would like to attend to his ailing father. Paragraph. Hence, I am inclined to allow the petitioner's prayer, and he is permitted to enter the jurisdiction of Dinhata Women Police Station. Stop. However, he shall attend each and every hearing before the learned trial court, in addition to complying with the other conditions specified in the order dated August 17, 2020.
Grateful.
All right. 5960 order record corona. Is state here? You want to do it? Not today. 5960, not today.
Grateful.
Lordship, may I permit to mention a matter, if you may, Lordship, for inclusion in the list.
Lordship, may I be permitted to mention, Lordship, for correction, Lordship, yesterday item number 88, CRA DB 03 of 2025, it was mentioned in the order to furnish bond before the ACGM court of Kuch Bihar. But Lordship, there's no ACGM court, Lordship, in Kuch Bihar. It's CJM court, Lordship.
To be mentioned tomorrow.
Grateful, Lordship.
Mention one bail in.
My lord, a leave may be granted, my lord. I'm appearing virtually, my lord, for a correction of order. Yesterday's order, my lord, in item number 17, there is a small mistake where notice has been mentioned as October, dated October 17, 2025. It will be 2024. My lord,
To
my
be mentioned tomorrow.
my lord, it can be kept on Monday to be mentioned.
Monday to be mentioned.
Item number 1.
Yes, Lordship, I am the appellant, Lordship. I am led by Mr. R.C. Guchati. He is
My
online.
lord, I am appearing by my lord, by virtual, my lord. I am praying your lordship, my lord. Yesterday, when the matter was taken up for hearing, I, my lord, submitted before lordship, my lord. Twice I sent my lord the application section 5 and stay application along with the memorandum of appeal. But on 2 occasions, on the address of the my lord degree, I sent the said parcels, but it was returned. That's why, my lord, I prayed before your lordship, my lord, to give me an opportunity so that I can get it published through newspaper or by any other way, my lord, substitute service. So your lordship, my lord, has kept the matter today as to be mentioned, and this is my humble prayer before your lordships. Kindly, I have my senior AG handing over the delivery
Listen now,
service, my lord, for
listen.
your.
This is an appeal from OIC. Enhancement of compensation.
Compensation, my lord, under section 80.
Affidavit of service filed in court today be kept with the records. Paragraph. Learned counsel for the appellant, comma, State of West Bengal, comma, says that at least 2 attempts were made to effect service of the appeal papers on the respondent, who was the plaintiff before the learned additional district judge, comma, first court, comma, Darjeeling. Stop. However, the papers have been returned by the postal department. What is the endorsement?
Sorry.
Paragraph. As requested by learned counsel for the appellant, comma, we grant leave to the appellant to effect service through to effect substituted service by publication in newspapers having wide circulation in the area where the respondent resides. Paragraph. List this matter before the next available circuit bench when evidence of substituted service will be filed in court by way of affidavit.
Grateful to lordship. Grateful to lordship. Grateful.
Actor Khalil directed at Kurida. Paragraph. We only put on record that this appeal is directed against a judgment and order of the additional district judge, comma, first court.
I don't have copy.
এক্ষুনি দাও তোমার একবার। তোমায় আমি বলেছি তো একটু আগে additional district judge কি এটা বলেছি। হ্যাঁ।
First court Darjeeling, my lord. Additional district judge, first court Darjeeling. First court, Darjeeling.
First court Darjeeling. On a proceeding. In a proceeding for enhancement of compensation for acquisition of the respondent's land. Next.
Get for your lordship.
Item 2. In this matter, I am for the respondent. If you also like sees the last order. And if you also first sees the order passed on 8th January and then on 27th.
No, so where is the appellant?
The appellants are repeatedly taking time in the executing court matter. And in before this court,
No section 5 has been filed.
No. The defects have not been cured, my lord. And
No, any order passed to cure the defect, right?
Yes.
On 27th January.
You can be cured positively within 2 weeks.
Yes. And prior to that one, on 8th of January.
Dismissed without further reference to this.
And
Which you got it.
And if you also since the order passed
Who
back
is
to that,
appearing?
Mr. Devoshidhar.
So
And if you also kindly sees the conduct in the court below.
No, definitely. If you can inform him, we can take it up
Well,
tomorrow.
I've informed him, he is not
Fine.
coming.
There's an order of the division bench. Why should we wait for him? Right? There's an order of a division bench, he has not complied with it. Sorry, no, I'm not agreeable. You want to differ. What is this? The division bench order রয়েছে এটাকে আমরা ইয়ে দেবো না, honor করবো না। Dismissed. What appear? Issue. By an order dated January 27, 2025, a coordinate bench had directed the appellant to cure the defects positively within 2 weeks, তারপরে court, failing which the appeal shall be dismissed without further reference to this court. Stop. Unquote. Paragraph, today nobody appears for the appellant. Stop. Learned advocate for the respondent says that no steps has been taken by the appellant for curing the defect, i.e. no application for condonation of delay has been filed. Stop. However, citing pendency of this appeal, the appellant is seeking adjournments before the learned trial court. Executing court. Paragraph, we have noted above that a coordinate bench had given a last opportunity to the appellant to cure the defects. Stop. In view of the conduct of the appellant, she having taken no steps for curing the defects, this appeal stands dismissed. এদেরকে কোনো sympathy দেখিও না চৌধুরী সাহেব, এরা এই করে এক্সিকিউটিং কোর্টে গিয়ে খালি বলবে অ্যাপিল পেন্ডিং আছে, পরে অ্যাডজার্নমেন্ট নেবে, আর এখানে কোনো স্টেপ নেবে না। হ্যাঁ, একটা পিটিশন ফাইল করলেই তো পারতো সেকশন 5, আর কিছুই দরকার ছিল না। এসব হচ্ছে কারসাজি। বলো, চলো। হ্যাঁ, এটা FAT হবে। This should be registered as FAT instead of FMAT. As noted by as noted by the additional stamp reporter, this appeal is against an order of dismissal ex parte by the additional district and sessions judge, and therefore should be registered as FAT instead of FMAT. Then what is to be done? Department will do the needful.
Lordship.
Paragraph, let the department do the needful to correct the classification oblique description of this appeal as FAT instead of FAT.
Let the matter appear on the next week.
So paragraph lists this matter once again on Wednesday date the other. This is not been admitted as yet. Before admission.
Before admission.
You were the defendant.
The defendant. Or the plaintiff. I was the plaintiff.
Ex parte, your suit was dismissed.
Matrimonial suit.
You didn't appear, it was dismissed.
My lord, I appeared, my lord, the wife.
Oh, very well.
Item 4.
For the writ petitioners, my lord. My lord, I am for the appellant, my lord. My lord, I am for the appellant.
Yes. Yesterday
My lord,
time was sought. Yes.
My lord, page 78. Page 78. Your lordship kindly have a look, my lord. I am appearing for the council. Primary council appellant, my lord. Primary council appellant, my lord.
You are appearing for whom?
Primary council, Jalpaiguri primary council.
You better tell us because we can't understand what he is saying. The connectivity is not good.
My lord, I have been instructed that, my lord, if your lordship, my lord, fix the matter on Monday, my lord, Mr. Taraprasad Haldar will appear physically and my lord.
No, I am appearing. He is also appearing. He is also appearing.
No, Mr.
Haldar
Haldar is for the
on page
council.
17 of the
Jalpaiguri primary council, the appellant. Lord, yesterday also due to some.
My lord, we are only, my lord.
May I?
Only on the last portion of the order we are only the interest part, my lord. Only the interest part, my lord. Hearing in terms of we have given hearing in terms of the order
next week, my
of
lord.
the single bench.
On Monday, my lord.
Kindly have a look page 79. Kindly have a look page 79.
Learned counsel for the appellants appear on the virtual mode. Stop. Due to very poor connectivity, comma, this hearing cannot proceed. Stop. Paragraph lists this matter once again on Tuesday.
Tuesday, my lord.
Chalo, next. Please explain
My
to
lord,
them no matter can be heard.
Absolutely.
You please address us. We are happy to hear you.
Lordship, Tuesday, my lord, if the my lord fails,
Yes.
but I will argue the matter.
As you lord. As you lord.
চলো হয়ে গেছে
Number 5, I'm fine.
মঙ্গলবার হবে
Not this week.
দেখো
Why yesterday time was sought?
বুঝলে
The paper book, Lordship, we
You are the appellant. It's your application for suspension of sentence. No, then let it go out of the list because no, what is this? Every day you will come and say not today, not today, not this.
হ্যাঁ বস না করি
Lordship
নে
paying for one.
হ্যাঁ বস না
Lordship.
Yesterday
God.
you prayed for the
Take it.
same.
Lordship, fund is accommodation, Lordship.
Not today, what to do? Not today.
Not today only. Tomorrow it will appear.
Lordship, then Monday,
Monday.
Lordship, Monday, it will be better, Lordship. I'm grateful.
হ্যাঁ এটা ভুলেও যদি কি দিতাম না ভুলে হ্যাঁ
Lordship, I am for the appellant.
Yes, how long you are in custody after conviction?
16 years.
After conviction.
After
2013.
conviction,
12.
13 years plus.
13 years. And prior to conviction, how many?
3 years something.
3 years. So total 15 years.
Maybe
Yes.
16 years.
No, as per the correction of this thing, that is correctional home rules, I think this this
Prior to, in
Yes.
trial court, the report given on 18/12/2023, he was in prior to, during trial, 2 years, 11 months, 23 days
okay, 2 years, 11 months, 23 days prior to conviction.
prior to conviction.
Okay, and 12
And-
years, so 14 years, 15 years you have completed,
No, more than that.
more than 15.
More than 15, as the total tenure is 13 years, 6 months, 26 days on 23rd October. No, August. No, sorry, December. Then 24th, 25th.
Convict হয়েছে তেরো থেকে, তাই তো? 13 থেকে 2 বছর, 13 থেকে 23 অবধি। তাহলে এর সাথে আরো 1 বছর, 1 বছর 3 মাস, মানে 14 years 9 months, তাই তো? 14 years 9 months।
না, বেশি হবে।
কি করে বেশি হবে? My lord, actually, he was convicted on
2013,
22nd of
August.
And up to 18/12/2023, the period is 10 years, 3 months, 26 days. Now, before that, when he was under trial, my lord, he was from 10/12/2028 to 14/3/2029, that is 2 years, 11 months.
23 days.
23 days, he was behind the bar. Now,
He preferred this appeal after 10 years from the date of conviction anyway.
so
That
now
was controlled.
from 18/12/23, that is 18/12/2024, 1 year, and another 3 months, 3.5 months. So 13 years, 6 months plus 1 year, 3.5 months. It's 14 years, 9 months, whatever it is. Now thing is that
ওটা কি বলে revision?
parallel to each other,
This act,
তাহলে কি দিয়ে দেবে নাকি রিটার্ন চেঞ্জ?
it
You
is.
know, long payment,
life is life.
হ্যাঁ, ঠিক আছে। বলে দেবে?
Life means 20 years, my lord.
Life means 20
20
years.
Yes, my lord.
Where it
Yeah, the
says so.
provision is there.
No.
Life
Life
means,
will be, yes, yes.
life means life. Who says 20 years?
Life is life.
No, till if you want, my lord, no, actually, if we assume this as per the CRPC, it has to be
No,
life.
under the new code.
No, old code, my lord.
Supreme Court has very clearly clarified.
That is-
Life imprisonment means
Yes,
imprisonment for life,
Life.
remainder of the life.
Now, what my lord was saying
That is
regarding the
different.
14 years jail
Yes,
code and
after
all.
14 years, the process for remission and
madam.
COVID.
After inquiry and their assessment, they start the process.
State,
That
that
the
is
state
pre-
will consider. But now, enough is
Now,
enough.
when at the time of bail, we consider the 1/3 period, so in that case, it has to be, in life cases, it has to be calculated up to 20 years. Yes, clear that. After 30,
যদি
20
যদি
years.
বলবেন আমি বলবো।
Arrangement they have to involve.
দিয়ে দাও তাহলে bill।
আমি কি বলবো না? Life,
You want to submit with regard to the merits?
না, না,
Simply on the custody, on the detection.
on the custody, and also this appellant is availing parole
বছর যদি
benefits.
তাহলে আরো এর favor।
And there is no adverse report.
Oh, he is availing parole benefits.
Yes.
For how many days? So
Practically, I have no details thereof, but he used to get facility of parole in regular manner.
57.
Now,
57, my lord. IPC.
I didn't know this.
My lord.
I did not know this.
My lord, that's right.
But regarding that commutation or remission, that is there, that provision is there. That after 14 years, the state government.
That is totally different. As per the conduct is jail. That is
Yes,
different.
that-
Totally
that is different.
We'll let him go, Mr. Chakraborty. Enough punishment he has suffered. Issue.
But several times he was in parole. He visited his house, his family.
And he has come back.
No, that is not counted actually regarding detention. That is not counted.
That is not. That is deducted from the.
This is an application for suspension of sentence filed in an appeal against the judgment and order dated August 20/22, 2013, passed by learned additional district and sessions judge, Mal, Jalpaiguri.
no, Mal,
Malbazar.
Mal,
Jalpaiguri.
আমি তো এখান থেকে পড়ছি মাল জলপাইগুড়ি
Na Bajar na Mali.
Mal, not Bajar.
Eh?
Mal,
Only Mal Jalpaiguri.
only Mal,
So
Jalpaiguri.
that is what I
That is there,
said.
that is there.
That is what I said, sir.
Yes, sir.
Mal, Jalpaiguri. In sessions trial number, in ST number, likho, 05 bracketed 12 bracket close 2009, arising out of sessions case number 274/2009, comma, whereby the petitioner /appellant was sentenced to suffer rigorous imprisonment for life and directed to pay a fine of ₹10,000 for commission of offence under section 302 IPC. Paragraph. The petitioner says that there are sufficient loopholes in the judgment under appeal and there is every likelihood of the petitioner succeeding in this appeal. Paragraph, however, comma, on a more important note, comma, learned counsel for the petitioner argues that in all the petitioner has now been in custody for, you just made a calculation just now,
14 years. My lord, page 94. my lord.
about 15 years.
Page 90. Of the Trefor book.
Stop.
14 years. 10 months.
About 15 years, Gaurav. ঠিক
About
আছে।
15.
Stop. Pre-conviction, he was in custody for about 3 years and post-conviction for about 12 years now. Stop. The state should consider the issue of remission and commutation of his sentence. Of his sentence in accordance with law. Stop. On the ground of lengthy detention and relying on the principles laid down in the case of Kashmira Singh, তো এটা বার করতে হবে 1977 এর Supreme Court, comma, he prays for suspension of sentence and release of the petitioner on bail, comma, pending disposal of the appeal. Paragraph. Learned state advocate tells us that on several occasions the petitioner was permitted to visit his family on parole. Stop. It is not the state's fault that the appeal has still not been heard out. Stop. The judgment sought to be assailed in this appeal is a well-reasoned one. Stop. There is very little chance of the appeal succeeding. Stop. However, comma, on the issue of long detention of the petitioner, comma, learned counsel fairly leaves the matter to the discretion of the court. Paragraph. We think that 15 years is a very long time period to spend in a correctional home. Stop. The state should consider the issue of remission and commutation of the petitioner's sentence in accordance with law. Stop. The very fact that on several occasions he was let out on parole and each time he returned to the correctional home shows the petitioner's bona fides and that he is unlikely to abscond if he is released on bail. Paragraph. Considering the very long detention of the petitioner and the principle of law laid down by the Honorable Supreme Court in Kashmira Singh, Supra, we are inclined to and do hereby grant bail to the petitioner. Suspension of sentences যে ফরম্যাটটা করা আছে এটা করে দেবে। আছে তো তোমার কাছে?
Suspension of sentence. I got a fine. Fine has to be paid, man.
Fine has been stayed already at the time of admission. Normally that is done. Hey, দেখি আরেকবার দেখি। Admission orderটা দেখি।
No, that has not been.
Normally when the appeal is admitted,
Normally, but I don't think
we stay the
Can
fine.
you say whether it was stayed, the fine?
No.
Please order.
Otherwise, just to come again.
appeal তো recent. Admit হয়েছে তো এখন?
হ্যাঁ, appeal admission হয়েছে।
No, you're right.
Otherwise, he'll be in problem. You can say he has to come again and again.
আরেকটা দিয়ে দাও তাহলে ওখানে। ওই যে ফরম্যাটটা যেটা ওটা দেওয়ার আগে। We also stay the portion of the order under appeal directing the petitioner to pay fine of rupees 10,000, till the disposal of the appeal. Correct.
I'm on behalf of the petitioner, my lord.
এই বইটা ওকে ফেরত দিয়ে দেন।
I'm on behalf of the petitioner. Bail in connection with appeal. It's a legal aid matter, my lord.
Yes, during trial, you were in custody or on bail? In custody.
Within 9 months, the trial completed, my lord.
9 months? The
Trial completed.
Total number of days you are in custody?
My lord, I am in custody for 1 year, 3 months, my lord.
No, I was asking, the case is of 2012, I think.
No,
No.
The case,
2023.
okay, 2023. Okay, 1 year, 6 months.
Yeah, my.
Oh,
The murder
भाई
case.
ये भाई ये देता victim ই ছোড়া নিয়ে এসছে। মেরেছে প্রভোগ করেছে ভাই দাদা দাদা তবে দাদাকে মারতে গেছে দাদা বুঝে দিন মেরে দিয়েছে
Self defense.
হ্যাঁ পরবর্তী ছেড়ে দাও You know? You know?
yes, what do you say?
Yes. The question of provocation was not even considered. The victim came with the knife, was throwing stones. Victim's elder brother comes out, tries to intervene. Victim tries to stab the elder brother retaliates, takes the knife. That's it. This is not 302, possibly it may come down to 304.
Most of the is done.
Hostile man.
Yes.
Single
Only one local, only,
Between the-
yes, one local person deposed.
Yeah, PW1 was the father. Has he lost one of his sons?
Correct, correct. We have read.
Not only daughter, my lord, she's the only breadwinner of the family, my lord. The daughter.
Everything was going to be recovered for the.
So who brought that murder weapon, whether the victim or the accused person?
And
That-
we know the truth, really, because most of the witnesses were turned hostile, even one of the were present.
The case of the prosecution is the accused person came and created this trouble.
Lordship.
The victim came. You are in custody for 1 year, 6 months.
My 1 year. One year, 5 months.
Including pre-conviction period. বলে দেবো এসো 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 This is an application for suspension of sentence in an appeal filed against a judgment and order dated July 30, 2024, passed by the Sessions Judge at Kalimpong in Sessions Trial number 4, bracketed 4, bracket close 2024,
Sessions case number
arising out of Sessions case number 3
of 2020.
of 2024, comma, whereby the appellant oblique petitioner was sentenced to suffer rigorous imprisonment for life and to pay a fine of rupees 20,000 for commission of offence punishable under section 302 IPC. Stop. Paragraph. The petitioner says that there are several loopholes in the judgment and order under appeal. Stop. Several key witnesses turned hostile, comma, including the victim's father. Stop. The issue of provocation was never considered by the learned judge. Stop. The fact is that the victim came with a knife and was throwing stones at the house of his mother. Stop. The appellant, who is the elder brother of the victim, came out and tried to stop the victim from misbehaving. Stop. The victim tried to stab the appellant, who retaliated in self-defense. Stop. In the process, the victim was stabbed. Paragraph. Learned advocate for the petitioner says that the petitioner is already in custody for 1 year, 5 months, including the period prior to conviction. Stop. He prays for bail, as there is very little possibility of early hearing of the appeal. Paragraph. Learned State Counsel, while opposing the prayer for bail, says that although certain witnesses turned hostile, still there was sufficient evidence for the learned judge to come to the conclusion as regards the guilt of the appellant. Stop. The judgment under appeal is well informed and well reasoned. Stop. Bail should not be granted to the petitioner. Paragraph. We have considered the facts and circumstances of the case. Stop. Firstly, prima facie, there appear to be certain loopholes in the judgment under appeal. Stop. However, this observation is in no way going to affect the hearing and disposal of the appeal. Stop. We see that we further see that the issue of provocation was not discussed by the learned judge at all. Stop. It is quite possible that the charge under section 302 may be scaled down to the charge under section 304. Stop. Paragraph. Further, paper books are ready.
Oh my God.
Direction was given for paper books. Given. Further, the appeal is not ready for hearing. Stop. Given that old appeals of 2016, 2017 are still pending for hearing, there is very little likelihood of this appeal of 2024, Taito,
Yes.
being heard on an early date. Paragraph. On the aforesaid considerations and on an overall assessment of the evidence on record and assimilation of the facts of the case, we are inclined to grant bail to the petitioner pending disposal of the appeal. সাসপেনশনের একটা আলাদা ফরম্যাট আছে, দেখে নিও। হ্যাঁ, এমনি বিলের মতন নয় কিন্তু।
No amount may be imposed money. He won't be able to pay money. These are legal aid matter money. On PR bond, he may be released money, personal bond money.
PR bond, personal bond. আচ্ছা, তুমি তাহলে ফরম্যাটটা দেওয়ার আগে একটা জায়গায় বলে দাও। Learned advocate for the petitioner says that the petitioner belongs to a marginalized section of the society and is financially extremely weak. Stop. He may not be able to furnish any bail bond. Stop. He should be permitted to furnish PR bond,
Personal bond.
PR bond. তাহলে ওইটা PR bond করে দেবে যখন ফরম্যাটটাই লিখবে PR bond.
I'm grateful.
Stop, this is a legal aid matter, সেটাও লিখে দাও.
I'm paying for not this fee.
Why?
The conducting advocate is engaged before the another court and he cannot come.
Very well, next circuit then. What is this?
Worship.
Somebody's liberty is at stake, personal liberty, and you take it so casually.
Apologize, but I was instructed to take adjournment.
Monday.
For item number 9 and for the petitioner, Ms. Oshima Lamna will be appearing in virtual, will be appearing on the virtual mode.
Why virtual?
Well, I'd like to apologize, Millets. I appear from Delhi, Millets.
Oh, Delhi, I see.
Please, Millets. I really apologetic, Millets.
The problem is, Ms. Lamba, the connectivity is not very good here. So we can't hear you very clearly. That's the problem.
Millets, I'll try and be louder for your lordships. If
It's
Millets,
not only a
I
question of-
apologize, but
it's
that's the
not-
best I can do at the moment.
It's not only a question of volume, it's a question of the quality of the sound. If your voice breaks
Please,
every second, how can we
Please,
continue like this? We can't follow what you are saying. It's not a
Please,
question of volume alone.
Please, Millets.
Your voice is breaking. It's garbled.
Oh, I'm so sorry, Millets.
Weather is brilliant here. Why don't you come over?
Millets, unfortunately, Millets, my client will not be able to afford it. That's the problem, Millets.
Are you ready today? Or you want?
Let's file certain judgments.
Millets, may I be permitted to, Millets, take your lordship to this suspension of sentence application, Millets?
Section sentence for,
Yes, we are not on the merits of the appeal as such.
No, judgments with regard to assailing the order of the trial court.
Judgments all give the root of the case.
That is the trial court's order.
No, Millets, this is for suspension of sentence. Millets, very briefly, Millets, I'd like to show your lordship, Millets, that the only allegation, Millets, in this case is that the appellant, Millets, he forcefully entered the room of the victim, Millets, and then, Millets, he attempted to commit rape, and the only description of that attempt that is given is that the father says in his complaint that the only allegation is he attempted to kiss her, which is, Millets, not attempt to rape. But, Millets, the prosecutrix in the 161 statement, Millets, and the 164 statement, Millets, she says that while she was fleeing away from him, he was trying to get a hold of her, and in the process, he touched her breast, Millets.
Oh, yes. Now, this is not live screening.
Live screening is not there.
No, Millets.